This is Michael Popok, Legal AF, real life consequences in a cascading series of decisions and comments coming out of the U.S. Supreme Court's decision just last week to take a look at whether the Department of Justice is properly using a certain federal criminal statute, obstruction of an official proceeding, against not only at least 300 Jan6 defendants, but one in particular named Donald Trump, because 2 out of his 4 counts of his indictment are for obstruction of an official proceeding or conspiracy related to it. It's a relatively new crime. It was put on the books in 2002 and the coming out of the Enron financial scandal. And the question that judges have in the back of their mind is it being properly applied to what happened on Jan 6th, when the Jan 6th insurrectionists, and by extension Donald Trump, blocked the Capitol and tried to break into the Capitol to physically stop the certification. Does that constitute willful and corrupt, which is the requirement, obstruction of an official proceeding? It seems obvious that it does, but if you look at the elements of the actual crime, that's going to be a question now for the U.S. Supreme Court. What's the real world implications of that? Well, just a week later, you have the one of the major federal judges, the former chief judge, Beryl Howell, commenting from the bench that now that it's up and in limbo with the U.S. Supreme Court, it won't get resolved until, if at all, until the summer. What do you do about all of the defendants that are being tried under that particular count, which is now at least in jeopardy or being questioned? And what do you do about the people who have already done plea deals or have been convicted that need to be sentenced pursuant to 1512? In other words, do the judges and the defense lawyers just ignore the fact that the major count, the major, cudgel, the North Star, the major stick being used by the Department of Justice, that particular claim, that 18 U.S.C. 1512 crime, it could be ripped off the books and ripped off the indictments? Do we just ignore it and act like it didn't happen when it comes to sentencing, and then just see what happens when the U.S. Supreme Court finally makes its ruling? See, when a U.S. Supreme Court like this one takes up an issue, even before they rule on it, it has impact on the administration of justice. You've now got judges like Beryl Howell questioning whether she should be dealing with that particular count at all in sentencing. And it's now going to have to reshape, at least for the next 6 months, how the Department of Justice prosecutors interact with the defendants. Because if they're making them plead to the 1512 count, there's going to be a lot of blowback if that conviction is overturned or vacated after the U.S. Supreme Court goes in the wrong direction and says that the Department of Justice was using it improperly and had effectively overcharged the case. And that's the risk right now in this sort of this moment of purgatory that the Department of Justice is in, where they're like, what do we do? We could lose the count if we make them plead to it, and that's the only thing they plead to. They could walk. Or now the calculus may be for the prosecutors, let's have the defendants plead to something else other than the now challenged 1512 obstruction of an official proceeding count, and have them plead to something else, so that if it gets turned around on us, we still have the conviction. That's the debate going on right now. And the judges are weighing in on it. When Beryl Howell, who's a very well-respected judge of the D.C. court, who had been the chief judge administering all of the Jan 6 cases until about a year ago, when she says, I don't think the Department of Justice should come into my courtroom right now trying to push down people's throats 1512 while the crime is being considered and could be reversed or ripped off the books by the Supreme Court. That's very troubling for the Department of Justice. And now the defense lawyers, including ones for Proud Boys and others, are jumping into it and getting into the act, and they're arguing, don't sentence us under that, because my sentence could be completely vacated. Some are even asking, let us out of jail while we're up on appeal, because that particular count that we pled guilty to or were convicted under could go by the wayside. This is the chaos that has been just created, not even by a U.S. Supreme Court decision, just their election to take an appeal And to decide whether that particular count is right or wrong is enough to send reverberations and cascading negative impacts through the justice system. And that's what I'm here to tell you on the hot take. Supreme Court, how do I put this? The Supreme Court impacts our justice system and our constitutional democracy in ways other than just making rulings. The cases they take, the cases they choose not to take, why they take them, the signal and the messaging they're sending to the Justice Department and to the judges and to the defense lawyers and to the defendants when they put a case up on the chopping block. Right? We're going to get a ruling on that in probably June or July before the end of the term. But in the meantime, you got defendants who have the charge against them, who have pled guilty to it. You have sentencing that has to go on. And now everybody's up in arms about it. Let me just read you from a very good Politico argument about article about what is going on right now in the court systems as a result of this decision. This is a very good article written by Robert Laguerre and Melissa Quinn. And here's what they had to say based on their reporting. Particularly, let's start with the quote. Beryl Howell warned from the bench just this past Friday of a possible backlog of cases involving that statute because they have not yet ruled or even taken it up on appeal. So that's her first warning. There are 327 defendants who have been charged with that crime. It's at the highest level. If you're doing this in a band of from worst to best, the worst of the defendants were getting charges like that, and along with seditious conspiracy. 50 have already pled guilty to the count and are either awaiting sentencing or have been sentenced and are already in the Bureau of Prisons, one way or the other. And of course, Donald Trump has 2 out of his 4 counts against him in the indictment in D.C. based on that very statute up for grabs. What Beryl Howell said, from the bench is that if some of the convicted defendants are asking to either have a pause in their proceedings if they haven't yet pled guilty or have been charged, or to have their sentencing delayed until they can figure out whether that statute is going to survive Supreme Court review or not. And she commented that that's not an unreasonable position. And she suggested the federal prosecutors before her, they should maybe narrow the plea deal to get rid of anything related to 1512 while it is in review, if you will, at the Supreme Court level. Now, separately, we now have, as I said, the defendants getting into the act, and the defendants are asking, for instance, for delays in their sentencing. One of the oath keepers, Thomas Caldwell, asked the federal judge overseeing his case to delay his sentencing that was supposed to be scheduled for later in December because although he was acquitted of the more serious charge, which was seditious conspiracy, he was convicted of the 1512 obstruction of an official proceeding account when he was tried along with the Oath Keeper leader Stuart Rhodes. The government is requesting 14 years sentence for Caldwell, almost entirely upon his finding of guilt on that obstruction charge. And so the question is, shouldn't his sentencing be delayed since he might end up prevailing that particular charge is illegal by the U.S. Supreme Court? Another particular Jan6 defendant and high-profile one, Kevin Seafried, he's the guy that carried the Confederate flag throughout the Capitol. We haven't seen that since the Civil War. Asked a federal judge in Washington to actually release him from his 3-year prison sentence because it is, in his view, it is likely that the 1512 count under review by the Supreme Court will be ripped off the books. And he had already been convicted of 5 different counts, including that obstruction count, and got sentenced on the higher count. So now we see what is happening. We reported it last week as a signal to Jack Smith about the legitimacy of that particular count and what would happen to Donald Trump's indictment. But now we're seeing the reverberating effects of just the Supreme Court taking on the decision and putting the statute in review is enough, right, to have defendants and their lawyers ask for stays to be released from prison, to have their sentencing delayed, to have their trials delayed, and now it has to impact plea deal arrangements and negotiations between prosecutors who now have to worry that they're going to lose, or could lose at least, the 1512 obstruction count. And that's the conversation I'm sure very aggressive lawyers are pushing back on the Department of Justice is, my guy's not going to plead guilty to 1512. You know, he shouldn't even been charged with 1512, and you may lose that particular count, Mr. Prosecutor, in just a few months. So let's cut a better deal. That is what's happening now behind the scenes, and that's what the purpose of this hot take is, to kind of keep you posted about that decision even before a ruling comes out and the impact it's having on our justice system. I do it on hot takes like this one place and one place only, here on the MeidasTouch Network. You can follow me on all things social media at MS Popok, and you can follow me on our long format podcast we curate for you twice a week. We call it the Legal AF Pod. It's exactly what you think it is. On Wednesdays, I do it with Karen Friedman Agnifilo, former prosecutor, a friend of mine. On Saturdays, I do it with my co-founder and the co-founder of the MeidasTouch Network and civil rights lawyer, Ben Meiselas. And then you can pick it up on audio podcast platforms of your choice. If you like this kind of analysis at the intersection of law, politics, and justice, you've come to the right place. And if you like this particular hot take, give me a thumbs up, leave me a comment. It helps keep me on the air. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.